Hi, everyone. Welcome. This is another installment in our series on antitrust developments from the New York State Bar Association's Monopolization and Big Tech Committee. My name is Pete Herrick. I'm a partner in the Antitrust and Competition Group here in the New York office of Melvin and Myers, and I'm here in my capacity as vice chair of the committee. And today we're going to talk about a fascinating and important case brought by the FTC that touches on monopoly power, among other important issues. And that's the agency's court challenge of Illumina's proposed acquisition of Grail. I am joined by Jordan Andrew. Jordan is a Deputy Assistant Director in the Mergers One division of the FTC's Bureau of Competition. He's been at the FTC for 14 years and previously served as counsel to the Director of the Bureau of Competition, attorney advisor to former Chair Joe Simons, and Special Assistant U.S. Attorney in the U.S. Attorney's Office for the District of Columbia. Recently and relevantly, Jordan co-led the FTC's challenge to Illumina's proposed acquisition of Grail and served as a handler for the FTC's primary economic expert. And despite having worked with me a bit while we were both at the FTC, he nevertheless kindly agreed to do this vlog with me today, for which I'm very grateful. And so just to tee things up before we dive into some of the key issues in the case, Jordan, can we set the stage with just a quick overview of the procedural history here?
Yeah, happy to do that. And thanks for the introduction, Pete. So before I begin, I want to make clear that my remarks today are my own personal views and not those of the FTC or any individual commissioner. And I want to stress that this matter is still ongoing, so I may be limited in what I can say, and I'll only be discussing publicly available information. So procedurally, obviously, there were a lot of twists and turns here. The FTC initially filed both an administrative complaint and a PI complaint in federal district court seeking to block Illumina's proposed acquisition of Grail. And that was back in March of 2021, so just over 3 years ago. Shortly thereafter, the EC accepted an Article 22 referral from multiple EU member states to review the Illumina Grail transaction. So as a result of the EC's investigation, which included a standstill order preventing Illumina from closing its acquisition, the FTC sought dismissal of its PI complaint since preliminary injunction relief was no longer necessary to preserve the status quo pending the administrative trial on the merits. Despite the standstill obligation, Illumina closed the acquisition of Grail in August 2021, just days before the FTC's administrative trial began. Then in September 2022, the ALJ dismissed the FTC's challenge of the merger, and the FTC appealed to the full commission. The commission, however, found that Illumina's acquisition of Grail violated Section 7 of the Clayton Act in a 4-0 vote, with Commissioner Wilson issuing a concurring opinion. Illumina then appealed the commission's decision to the Fifth Circuit Court of Appeals, which ultimately issued a decision in which it agreed with much of the commission's decision, but vacated the decision and remanded it to the commission for further proceedings, finding that the commission had applied the incorrect standard in reviewing Illumina's proposed remedy, which was referred to as the open offer. And then finally, a few days after the Fifth Circuit issued its decision, Illumina announced that it would divest Grail.
Okay, so with that as the backdrop, the products at issue in this case, the DNA sequencing and MCED testing are complicated, to say the least. But as in any antitrust case, in order to decide whether the transaction may substantially lessen competition under the Clayton Act, the trier of fact, which is usually a judge in these cases, needs to understand how the products actually work, who the current and potential competitors are, entry, expansion, innovation, and more, just to name a few. So at least part of the advocacy for both sides has to entail educating the court, which can make advocacy a little bit trickier in some cases. So just to take a step back, imagine the audience, we're just a generalist judge learning about this stuff for the first time. Can you give us a primer on DNA sequencing and MCED testing and what they are and why they're important?
Yeah, I'll do my best. This obviously involved a lot of educating ourselves to begin with, given the complexity of the products. But so basically, this case involves Illumina, which is the dominant provider of DNA sequencing services, acquiring Grail, which is a developer of a clinical test called a multi-cancer early detection, or an MCED test. I'll try to give an overview without getting too deep into the scientific weeds. So as the name suggests, DNA sequencing is a technique used to determine the sequence of bases or base pairs or nucleotides in a DNA molecule. And that's important because DNA sequences are essentially the recipes that cells use to make proteins and carry out various bodily functions. Then if there are changes or mutations in a DNA sequence, those can sometimes lead to certain diseases, such as cancer. So basically, if you know the sequence of a piece of DNA, you may be able to determine whether it's actually a biomarker for cancer. At a high level, that's why DNA sequencing is important. Now, what does that have to do with MCED tests? So when cells die, they release their DNA into the bloodstream in small fragments, which are called cell-free DNA. The same is true even for cancer cells. But when they release DNA into the bloodstream, it's known as circulating tumor or ctDNA. And that's where multi-cancer early detection tests come in. So MCED tests rely on DNA sequencing to analyze these cell-free DNA fragments in a person's blood and detect whether any of them have this circulating tumor cancer DNA. Because it's a blood test, MCED tests are referred to as liquid biopsy tests. And they're much less invasive in this way because they only require a blood draw rather than actually taking a tissue sample from someone's body. Now, importantly for this case, MCED tests work particularly well with Illumina DNA sequencers because Illumina can efficiently sequence large numbers of these short strands of cell-free DNA. So for applications like MCED testing, where high volume of sequencing and low cost is particularly critical, no other company offers DNA sequencers that combine similar throughput, accuracy, and cost as Illumina does. Illumina does face some competition for sequencing in other types of applications, usually those that involve analysis of longer DNA strands, such as whole human genomes. And that's what we saw in Illumina PacBio, which was a case that we filed a complaint on just before Illumina Grail, alleging that PacBio's long-read sequencing was a nascent competitive threat for certain sequencing applications. But in this case, the Fifth Circuit, the Commission, and the ALJ found that PacBio and other sequencing companies were just not practical alternatives to Illumina for MCED tests. And that, hopefully in not too long of an explanation is why Illumina DNA sequencers are a critical input for MCED testing.
Yeah, I think I followed that. It is extremely complicated, but that was about as clear as it could possibly be, I think. And I'm sure as we go forward, some of this will make even more sense. There was another procedural twist here, which you alluded to at the beginning, which is that in this case, it wasn't just a U.S. court decision that was at issue. It also involved the European Commission. So can you just talk briefly about the role that DG Comp played in this process and how that played into the FTC's decision making on where to file its challenge to the deal, if at all?
Yeah, absolutely. So as I mentioned before, the commission issued an administrative complaint and staff filed a PI complaint, which is what we typically do when we challenge unconsummated mergers in order to maintain the status quo pending the administrative trial on the merits. And those complaints were issued before DG Comp had announced that it had accepted requests from other member states to assess the proposed transaction. And before it publicly stated that Illumina and Grail, as it said, they cannot implement the transaction before notifying and obtaining clearance from the commission. So again, in terms of our decision to issue an administrative and PI complaint where we filed, DG Comp played no role in our decision regarding when or where to file its challenge to the deal. Now, when DG Comp announced that it did that it had accepted requests from member states to investigate, it implemented, as I referred to before, a standstill obligation during the pendency of the investigation, which is kind of like what we do after we issue separate requests. So at that point, the FTC's relief that it had sought in federal court was no longer necessary since the parties couldn't close their deal while the EC investigated, and the status quo was still being maintained. The district court where we filed our PI complaint agreed and dismissed the PI complaint without prejudice. But again, we continued to move forward. Despite dismissing the PI complaint, we moved forward with the Part 3 administrative process, and that trial commenced just a few months later. So yeah, we were surprised by Illumina's decision to close the transaction over the EC's standstill obligation. Illumina did agree to hold separate, simultaneously when it closed the deal, agreed to hold separate with the EC. But the EC did eventually also fine Illumina about 432 million euros for closing the deal when it did. The EC then continued its investigation, ultimately found that the deal would substantially lessen competition, and ordered Illumina to divest Grail. And I should note that Illumina has appealed the EC's exercise of jurisdiction, the fine, and the finding that it would lessen competition.
Yeah, and 432 million euros, that's not nothing. That is a fairly significant fine, I think, by most standards.
I think it was a record fine, actually.
There you go. So shifting more towards, I guess, the substance of the case and where the issues were that the FTC was concerned about. One of the key questions that has made this case so important and I think interesting is how courts should think about the importance of competition in R&D and innovation. That was a key feature of this case. This was also a vertical merger. And of course, as everybody knows, these issues are very prominently featured in the new FTC and DOJ merger guidelines, but we don't have a lot of cases dealing with them, where they've been analyzed extensively by the courts. And, in fact, if you think about vertical merger cases, those are litigated vertical merger cases are pretty rare, and appeals court decisions in vertical merger cases are essentially unicorns. They're extremely rare, almost mythical. So can you put those issues in perspective for our audience? I guess maybe just to take a step back, what were the concerns that the FTC had with the deal, and how did you think about presenting those concerns to the court so that the court didn't feel like it had to go out on a limb or break new ground if it was going to rule in the FTC's favor?
Yeah, I'll kind of try to take all those issues in turn. And as you mentioned, yes, vertical mergers, litigated vertical mergers in particular, are unicorns. This was the first vertical merger that the FTC litigated to a decision in several decades. So it was an opportunity for both the commission and a federal court to analyze a vertical merger, under a couple of different standards. So the FTC alleged that the transaction was an illegal vertical merger under both the ability and incentive standard and the brown shoe vertical factors. And the issue, as a general matter, was foreclosure. So foreclosure disadvantaging Grail's rivals. The ability and incentive standard, which is all over economic literature, and was used by the district court in AT&T Time Warner to assess the competitive effects of that merger, has been kind of the dominant or accepted standard for vertical merger analysis over the last many years. Then Brown Shoe, of course, is the Supreme Court precedent that's more often associated with making product market determinations in horizontal mergers, but it also provides a multi-factor lens for evaluating vertical mergers. So the commission majority applied both of those standards, though Commissioner Wilson, in her concurring opinion, endorsed only the ability and the incentive standard. And the Fifth Circuit held that under either standard, there was substantial evidence to support the commission's finding that the merger may substantially lessen competition. So, as you're alluding to, this represents the only recent case in which a court applies and finds liability under these tests for harm in a vertical merger. And then you can see how both tests are reflected in the new merger guidelines. And in the section of the guidelines that discusses those tests, there are citations to Illumina, Illumina having come out mere days before the guidelines were issued. The other interesting aspect of this case that you mentioned is that involved R&D and innovation competition. So I think the most important reference, if we're talking about the guidelines here and Illumina's impact on them, the most important reference in the guidelines to Illumina comes in a small section involving innovation competition. This is section 4.3 D7 in the guidelines, which is a short section that addresses markets defined around, and this is the quote that they use from the Fifth Circuit, what developers reasonably sought to achieve, not what they currently had to offer. And that really, that was the crux of the FTC's case, that essentially a market already exists today around the research, development, and commercialization of MCED tests. And that it includes Grail and a number of other MCED tests in active development, instead of just defining the market around tests that have already launched and are on sale, which would have included only Grail. I think it's important to note that at each level, the ALJ level, the Commission, and the Fifth Circuit, they all agreed with the FTC's market definition. So the Fifth Circuit also did not require the FTC to prove the relevant market through quantitative means, such as the hypothetical monopolist test, and stated that such a requirement would, as it said, in effect, prevent R&D markets from ever being recognized for antitrust purposes. And the guidelines again incorporate this by stating that the agencies may define relevant antitrust markets around the products that would result from that innovation if successful, even if those products do not yet exist. Just really quickly, I wanted to also point out, there's a bit of a difference here between how we think of competition for R&D or innovation markets and a more of a traditional potential competition case. So this was not, we did not plead this as a potential competition case. We didn't allege potential competition standards here. The focus was instead whether Illumina could disadvantage other MCED developers, resulting in a substantial lessening of R&D or innovation competition. But it does have echoes of potential competition. And interestingly, in the Fifth Circuit opinion, there's a footnote, footnote 7, that highlights a quote from Marita and Hovenkamp stating that the difference between actual and potential competition for purposes of antitrust enforcement is often exaggerated. And, it may be surprising for a lot of people steeped in antitrust law to read, because most practitioners tend to view current and potential competition as almost entirely distinct, or at least subject to very different economic and legal analyses. But I think the Fifth Circuit leaves open perhaps whether some future merger that may ordinarily be thought of as potential competition could instead be thought of as current competition in R&D or innovation market, or potentially even pled under both standards.
Yeah, I think that's a great point. And I think there is often, at least in the private bar, the way many of us think about it is, well, potential competition is sort of, there's a new entrant on the horizon. They're really, it's a little bit speculative maybe, but, that's potential competition, as opposed to competition for innovation or R&D, which could be happening right now. And maybe those lines are a little bit blurry sometimes, but this is really I think one of the first cases to really look at that in any kind of detail. So it's a really helpful case for those viewers thinking about those issues to really review and think about. One other aspect of this case, which we have seen more of in some recent cases, merger litigation, is the idea of litigating the fix. And here, Illumina attempted to address the FTC's concerns, or at least avoid getting their deal blocked through an open offer, which the Fifth Circuit described as somewhere between fact and a remedy, because it was made after the litigation had already started and hadn't sort of gone through the traditional remedy process within the FTC. So I know the case is technically still ongoing, so you have some constraints about what you can talk about here in this aspect of the case. But can you give us a sense of the evidence on the open offer and how the Fifth Circuit thought about it in its decision?
Sure. Obviously, the open offer was a critical part of the case. So it was the open offer, just to kind of describe it again, this was a public long-term supply agreement that Illumina offered to Grail's rival MSED test developers in an effort to kind of assuage the FTC's concerns about the proposed transaction. The FTC and Illumina just disagreed as to how the open offer should be analyzed. FTC argued it should be analyzed as a remedy and thus not taken into account until after the liability phase, whereas Illumina argued that it was a market reality that the FTC had to take into account in its own prima facie case. And as you mentioned, the Fifth Circuit really came down somewhere in the middle, saying that the open offer should be analyzed before finding of liability, but that the burden should be on Illumina to kind of present evidence about the open offer as part of its rebuttal case. The other thing that it held was that because it's not a remedy, and where the FTC usually thinks of remedies as having to kind of restore all lost competition that may have resulted from the deal. The Fifth Circuit said, well, that actually goes against the plain language of Section 7 of the Clayton Act. It need only bring it back to a point where the merger does not substantially lessen competition. So because the Fifth Circuit held that the commission used the wrong standard, that's why it vacated the decision and remanded it back to the commission. The Fifth Circuit, though, didn't express a view on whether application of the proper standard, if the commission had applied the proper standard, whether it would have changed the outcome of the case. So in terms of the evidence on the open offer, just really briefly, that was mostly contained in the commission decision. The Fifth Circuit really dealt more with the standard. But the commission decision, kind of went through a bunch of pretty significant flaws that it found with the open offer. It found sort of at a high level that the open offer still leaves Illumina with a strong incentive to favor Grail over its rivals, and that it would have the ability to do so given how reliant the MSED test developers are on Illumina sequencing. So Illumina provides not only sequencing services, but also service and support, access to new technology, regulatory approvals, and other similar types of assistance, which are all very important to the competitiveness of Grail's rivals. For example, if Illumina delayed servicing of the sequencers that it provided to Grail's rivals, it could result in longer turnaround times, which could impact the competitiveness of the product. So this, as well as a firewall provision for information sharing, were concerns that some of the MSED test developer rivals had that the commission detailed in its opinion. The commission also found that Illumina's contemplated enforcement mechanism, which included an audit and confidential arbitration, would result in time lags, essentially, that were too long to resolve even minor disputes. and that those measures would come probably after damage to the rival's competitiveness. So that's some of the evidence that the commission found about the open offer.
Right. So I'm going to shift into lightning round mode here. So case isn't over. Back with the FTC on remand, can you just sort of peer into your crystal ball and tell us what you see as the potential paths forward?
Yeah, as I mentioned earlier, Illumina announced publicly that it would divest Grail. That doesn't mean that the FTC or the EC's job is done. For example, our compliance division always reviews divestiture plans as well as potential buyers. Here, since the commission order to divest Grail was vacated by the Fifth Circuit, the only current standing order to divest is from the EC. And recently, you may have seen, this is very recent, the Advocate General to the ECJ, European Court of Justice, issued an initial decision reversing the EC's assertion of jurisdiction under Article 22. And so a final ECJ decision has not been issued, but Illumina again publicly stated that it will continue moving forward with its plans to sell off Grail regardless. I can't get too much into the details of what's going on at this point at the commission because, as I said, the matter's still ongoing. But in February, the commission issued an order directing the FTC and Illumina to submit a joint status report apprising the commission on Illumina's plans to divest Grail. And in the order, the commission also stated that the commission was prepared to address the one remaining issue remanded by the Court of Appeals. Which is the analysis of the open offer that I just discussed. So that's probably the extent of what I can comment on at this point.
All right. Still lots of twists and turns ahead. Final question in the lightning round here. What about efficiencies? There were efficiencies arguments in this case. What happened?
There were, to try to fit this in under time, I'll just mention, I'll highlight two of them for you and sort of where the Fifth Circuit came down. So Illumina had a claim, and this was part of its rationale for the deal, that it would be able to accelerate access to Grail's MCED test by a year through quicker FDA approval and payer reimbursement. Well, the Fifth Circuit agreed with the commission's opinion that Illumina did not establish that it could accelerate either FDA approval or payer reimbursement, or show how that acceleration would be achieved. So for support, the Fifth Circuit pointed out that Illumina's own financial models of the merger didn't assume that Illumina would be able to accelerate commercialization of its test. It also agreed that contrary to Illumina's arguments, Illumina lacked expertise in obtaining FDA approval for clinical tests, and that Grail itself had poured significant resources into approval and reimbursement efforts already. And just really quickly, one other efficiency that I think is worth highlighting is the treatment of elimination of double marginalization, or EDM. The Fifth Circuit treated EDM as an efficiency rather than something that the commission must account for in its effects analysis, and held that Illumina, not the FTC, must demonstrate that the intended acquisition would result in significant economies, including EDM. I think it'll be interesting to see whether other courts follow the Fifth Circuit's lead in thinking about EDM as an efficiency.
All right. Well, that's all we have for today. I want to thank Jordan for this incredibly informative and really interesting discussion about a case that I think folks should really pay attention to because it touches on so many different issues that come up in mergers all the time. And if you're thinking about a deal that might get challenged in court, or if you're just thinking about how you might want to persuade FTC or DOJ staff that your deal doesn't raise concerns, this is a case to really dig into. I also want to thank the audience for joining, and I'll just say stay tuned for more episodes coming your way soon. Thanks a lot.